First of all, on behalf of Greenway Chambers, I'd like to welcome you all here tonight for another of the CPD sessions. This one's on Coronial Inquests and Inquiries, presented by Hernan Pintos-Lopez and Tim Hackett, who will provide an outline and a guide for US practitioners for appearing in coronial jurisdiction. As I understand it, they'll be touching upon, in general terms, the uniqueness of the jurisdiction, general ideas about practice and procedure, and interestingly, managing reputational risk, which I'm looking forward to hearing about. Both Hernan and Tim have significant experience in this jurisdiction generally, but Hernan in particular in relation to bushfires, Tim particularly in relation to what I'll describe as medical misadventure. There will be an opportunity... Beg your pardon? Bushfires, medical misadventures in the bush, with fire involved, is Tim's specialty. At the end of the presentation tonight, there'll be the opportunity of asking questions, including for those of you who I understand are online watching in the Ethernet. There's apparently a feature whereby you can indicate you have a question and we can boom your voice into the city. So without further ado, I'd like to introduce Hernan and ask him to enlighten us. Hernan.
Thanks, Richard. Thank you very much. And thank you for coming along. This is a great experience. Basically, it's been a while since we've actually had these things with people, so it's great. I just, starting off, I'd just like to make the point that this presentation is directed primarily at practitioners who are acting for interested parties. My presentation in any event, and for practitioners who may be less familiar with the jurisdiction. I'm not assuming any sort of level of familiarity, but going to be making some points that many of you will feel are pretty obvious, and that's the joy of being counsel. You get to make obvious points. And, so I guess I'd start just by saying very briefly that losing a loved one is obviously, or suffering the loss of a home can be one of the most tragic circumstances, one of the most difficult experiences that a person can go through. And in the coronial jurisdiction, you'll often find yourself sitting barely a few feet away from these people who have, suffered this terrible loss. They can be very diverse experiences, and they all come within the coronial jurisdiction. For example, a young woman who takes her own life after coming into contact with health services. A young man who jumps from a cliff, with friends and jumps into a swimming hole but doesn't resurface. A little boy who's playing on the beach and he's taken by waves and taken out and he drowns. Those are just three cases that I've done, and it's always difficult because you've got a job to do, but there's that human aspect of it, so a coronial inquest or inquiry, and inquiry is probably the lesser known of the two. Most people are familiar with inquests, you hear about them in the news, but there's also a power to hold inquiries into a fire or explosion, and I'll touch on that a little bit later. I've done a few of those. So just starting with, so these are the matters that I intend to touch upon, and necessarily given the time I'll be pretty brief with most of them, but I just wanted to emphasise, I think as Richard said, the unique aspect of the coronial jurisdiction, and certainly if you do royal commissions or commissions of inquiry, there are similarities, but it's important to remember here that coroners, I think this is a recent decision of Justice Hamill in the New South Wales Supreme Court, which I just thought summarised it really nicely. Coroner's Court is a statutory court, the jurisdiction and powers of which are encompassed in and governed by the provisions of the Coroners Act. And another decision from South Australia, where Justice Hughes said an inquest is a process directed at ascertaining facts upon which recommendations may then be formulated. Very simple, very succinct statements, but they capture so much more. You'll see that there'll be a bit of a recurring South Australian theme in some of these authorities, not for any particular reason, but they just had some quotes that I really quite liked. But in New South Wales, Justice Ip in Musumeci said a number of years ago, the coronial process is a hybrid process containing both adversarial and inquisitorial elements, and that coroners exercise judicial power, notwithstanding the executive nature of their functions. I think the thing to remember here is that basically it's a strange creature. Coronial jurisdiction is basically, it has the appearance of judicial hearing. You've got a magistrate in a court conducting a hearing in the manner of a judge, hearing witnesses, hearing cross-examination, applying the law but not determining the rights and obligations of parties, and making findings of fact, and usually recommendations, in the form of a report. So it has those aspects of sort of the executive function. So just with those brief observations. I saw a CBD recently where a panel was talking about the oft-quoted saying that it's not the function of a coroner to determine or appear to determine any question of criminal or civil liability, to apportion guilt or attribute blame. That was the thing they were talking about. And opinions were divided as to whether or not that's accurate. But I guess it led me to think, well, maybe it's worth having a look at that and actually what it means, because I think that sheds some light on what you're doing when you're actually in the coronial jurisdiction. And as counsel, when we appear in the coronial jurisdiction, what we're doing. Now, that idea is also reflected in the practice note. Practice note actually says coronial proceedings are not adversarial in nature, and they don't involve adjudications of criminal responsibility, etc. That's uncontroversial. They don't determine any of those matters. But I think it's fair to say that once you've spent time in a coroner's court, you'd be forgiven for thinking that the cases are referring to some different jurisdiction, because in practice, you find yourself where facts are often disputed, they're hotly contested, and proceedings can have their adversarial aspects, especially where there are related civil proceedings. So there might, for example, be an inquiry with a class action waiting in the wings. There might be some medical misadventure with potential proceedings for negligence. Those are typically the backdrop, and whereas it might be in sequence, but it might be in parallel as well. Certainly I've been involved in cases where the two proceedings are actually running at the same time. And that creates all kinds of interesting scenarios, because it's almost a dress rehearsal. You get to see the evidence, both sides get a benefit from it, but what gets in is obviously different because there aren't rules of evidence, but we'll touch on that a little bit later. I included this quote because this is a famous statement from Ex parte Thompson, which is cited by Justice Toohey, Annetts and McCann. I think the relevant point of this is that it's a fact-finding exercise. It's an investigation. And I think that's the thing to remember at the end of the day. And that gives it a completely different complexion, much more like a Royal Commission, much more like a Commission of Inquiry than like normal litigation in that sense. Just on that, I just want to say that certainly it's my experience that coroners seem to have very little patience for interested parties who are a bit too obvious in using the coronial for their own litigation purposes and seem to be advancing an agenda that seems to go beyond the scope of the inquiry itself. And it can apply to both plaintiffs and defendants. But to come back to what was said earlier, particularly the principle that's enshrined in the practice note, I think the key thing to remember is that it is obviously part of the coroner's role to make findings as to causation. For example, was there a person whose actions caused or contributed to the death? What caused the fire or explosion? And that role necessarily involves a question of responsibility, at the very least at a factual level. And that's really that's really the point. And I also just included an extract from a case called Saraf and Johns from South Australia, where focuses on the practical aspect and the fact that the coroner, the focus on common sense. But I particularly like the expression, one problem with common sense is that it is not all that common. Now, that wasn't to suggest that coroners don't have common sense, but rather to say that what is actually common sense, reasonable minds can differ, and they do differ, and it depends on who you draw and what their view is. And I think that's worth remembering. Coroners are going to differ in their take on things. So, I mean, an important aspect of that, I guess, also is that different coroners will differ, for example, in what they make of a particular witness, the weight they give to different parts of the evidence, and so, that's why part of advocating in the coronial jurisdiction is to try as best you can to adapt your style to what works, to what's being what is constructive to advance your client's case. So as I said, the Act is directed to the making of findings about manner and cause in the case of a death, or cause and origin in the case of a fire or an explosion. And they must necessarily touch upon issues of responsibility, at least in the factual sense. So I just thought I would briefly give you a Cook's tour of some of the key provisions, because I think it's interesting that when you appear in the coronial jurisdiction, each case raises its own issues. Sometimes there are provisions that don't have any particular reference for the inquiry that you're involved in, and then other times there'll be certainly sections that are tremendously relevant depending on the case you're in. You might, for example, find yourself in the middle of a coronial scene investigation where there are police involved in taking evidence and seizing objects, or there might be issues about documents. But just briefly, I'm just trying to highlight here, I guess, the main provisions. So the power in Section 21 is the power to conduct an inquest in the case of a death. The focus is on the manner and cause, and that's also replicated in Section 81. Section 27 sets out the mandatory circumstances in which an inquest is required to be held. Now, as I said before, Section 30 is the lesser known power, which is the power to conduct inquiry where there's a fire or explosion. And the focus there is upon the cause and origin. Now, as an aside, in fire investigation science, that's actually reversed, because you actually need to find out the origin before you can work out the cause, but I'm sure the drafters weren't thinking about that when they drafted it. Section 49 really, I think, is interesting, because it really emphasises, if you like, the procedural flexibility of the jurisdiction. The coroner can give such directions as the coroner thinks fit, and can run the case as the coroner thinks fit, subject to practice notes and obviously the Act. Now, Section 58 is of course tends to fit with that in the sense that a coroner is not bound to observe the rules of procedure and evidence that are applicable to come back to that, how that plays out quite often in practice. But there are many jurisdictions where there aren't rules of evidence, but in the coronial jurisdiction there are some particular features to it, and I'll touch on those in a little while. Now, Section 78, this is not intended to paraphrase the section. It's a very complex provision. I just want to highlight it's there. So this is a provision that deals with circumstances where there is either a person being charged with an indictable offence in relation to the relevant death or other circumstance, or where the coroner themselves forms the view in the course of the inquiry that it could support a charge in relation to an indictable offence that could be accepted beyond reasonable doubt. As I say, not intending to paraphrase it, it's very complicated, but I just wanted to let you know that that is there because it's a key provision in cases where there's an interaction with criminal proceedings. And importantly, of course, Section 81, which requires the coroner to record findings in writing, and related Section 82, which is the power to make recommendations. In some very rare cases, there won't be recommendations, but usually there will be. I think I've only had one case where there weren't, where the coroner formed the view that what was being done was already sufficient and that there didn't need to be any further recommendations, but that's unusual. So it's one of the interesting aspects of the coronial jurisdiction, where you take a particular case and you try to make some general recommendations of wider effect for social improvement, basically, for policy improvement, for social improvement. Now, finally, I just wanted to highlight Section 85 because there are no appeal provisions in the Act, but there is this facility in Section 85 which is not often used, but it allows the Supreme Court to quash an inquest or inquiry and order a new one. And I'll come back to that in a little while. But just moving quickly, I just wanted to highlight three aspects of practice and procedure. Now, the first is one that I've already touched on to some extent, which is the flexibility of the practice and procedure. And you find sometimes that, for example, the coroner may determine that a view should be held. So you go to the place, you can see where the fire occurred, where the person jumped, and it's a very immediate experience for the people who are involved. Now, I just wanted to emphasise that typically things are run very lean, and there'll be a directions hearing before the main hearing, and that's usually the time to raise any issues that are there. It's the time to finalise the issues list. It's the time to seek leave to appear for people who, persons or parties who have a sufficient interest, and it's the time to work out a timetable for evidence. You can find a sort of more detailed exposition of that in the practice note in part 7, but I just want to emphasise that, again, there's that flexibility, but typically there'll be the directions hearing and then there'll be a timetable for the hearing itself and for evidence and the things that go with it. The other thing which is interesting about the coronial jurisdiction is the issues list. Typically up until that point it's in draft form, and sometimes it's finalised at the directions hearing, sometimes it's finalised at the very hearing itself. But given the absence of rules of evidence, the issues list defines relevance. It's relevance to the issues. And that's something the coroner can themselves amend. So you're in this strange situation where it's in effect as if the pleading is being drafted by the judge, in that sense, because the whole question of the scope of the inquiry is really open to the coroner. So relevance is necessarily a broad concept, and it can be difficult at times to say something isn't relevant. The third thing I wanted to highlight there, I guess, is the role of counsel assisting. I'm sure most of you, if you practice in this space, already know this, and I'm probably stating the obvious, but in most cases, the advocate who assists the coroner will actually be a police advocate. In some cases, it'll be counsel assisting, but there are many cases where it'll be a police advocate. Now, that person, whether it be counsel assisting or the police advocate, performs a similar role. They give an opening, they advise the coroner in relation to the witnesses to be called and the order. And this, I guess, is one of the main differences. Parties who participate in litigation expect that they have a right to put on evidence. Obviously, in the coronial jurisdiction, that's not the case. Evidence is tendered through counsel assisting. And that's a pretty significant difference. Now, finally, counsel assisting's role also extends to the making of submissions about proposed findings. Now, in many cases, that will be quite influential in terms of the final outcome. What's interesting also, I think, about counsel assisting is that they'll often have their own working case theory of what happened, but they don't have a horse in the race. They don't have a stake in the case, and often I find that you'd hope that they will form their own reasonable assessment of the evidence, but also find that they're quite a good barometer of your own case, because often if they're not buying what you're selling, it's pretty likely the coroner won't be buying what you're selling either. So I think it's quite a good way to gauge really the good sense of what your case is, basically. Now, obviously, counsel assisting also has the heavier job, because they are the ones who essentially conduct the examination of all of the witnesses, and through a mix of sort of leading and non-leading questions, and then interested parties have a chance to cross-examine, typically. But obviously that, when you appear, your relationship with counsel assisting is fundamental to how that inquiry will go for you. So having a good rapport is a good thing, and having open channels of communication is a good thing. So I'll just move on briefly to questions of evidence. Obviously, coroners aren't bound to observe rules of evidence, but our job quite often is to encourage them to at least pay regard to the principles behind the rules of evidence, because they are a good guide to what's reliable, and coroners should make decisions on the basis of material that is reliable and probative and relevant, obviously. But in practice, because coronial proceedings have a very strong practical, factual focus to them, you'll often see hearsay and opinion evidence just flowing freely. People who have no particular expertise will be invited to give expert opinions on all manner of subjects, and ultimately the coroner will weigh this material up and come to a view. Now, there is scope to object to evidence, but obviously our role as practitioners is to approach those sorts of objections with care. And in particular, we know that technical objections just won't fly. But that doesn't mean that there's no role for objections to evidence in coronials. And in fact, particularly if you frame your objections in terms of issues of relevance or competence, you may get a better reception. But ultimately, I guess the point that I'm trying to make here is that what you should be doing is keeping an eye on your ultimate submission. There's no point in pursuing objections on minor issues because you're just wasting the coroner's time. But even if you're unlikely to be successful, there can often be a value in raising an issue about the material because it provides, at least it marks or it highlights in the coroner's mind the question as to the reliability of that material. And it provides, if you like, a platform for you to make that submission ultimately in your final submissions. So, in other words, even if you think you are likely not to succeed, there can be times when you do want to raise those issues because you might find that ultimately they are accepted in the final result. Now, I just want to highlight an example from a case where I appeared in this inquest in relation to a young boy who was taken from the beach while he was playing, basically by the waves, and dragged out to sea. Now, in that case, I was appearing for a government agency, and there was a substantial dispute as to who actually owned the beach, and as a result, who was responsible for putting up things like warning signs. Now, in that case, one of the witnesses was a person from a local lifesaving club who was asked to give evidence. In fact, was the only evidence there was up until that point about the ownership of the beach. Now, I objected to the evidence on the fairly simple proposition that it's a legal question and he couldn't possibly shed any light on it. But the way in which I did it wasn't really in the manner of a formal objection, but the point that I made to Her Honour at the time was, Your Honour wouldn't accept it. This is evidence that can't possibly shed any light on the question Your Honour has to conclude. And it happens that there was, in fact, after that point, some evidence from my client about the ownership, land records as to who in fact owned the land. So there'll also be circumstances where you can encourage better processes. If you've got non-experts purporting to give evidence about matters that are properly the subject of expert evidence, you may fail, but you can at least try to encourage those assisting the coroner to get proper experts to deal with it, whether it be psychological or medical evidence that's required. Finally, I don't know how I'm going in terms of time, but I'll skip through some of this material. Really, all I want to emphasise here was that, and it's interesting to contrast the position in other states. So, in South Australia, for example, there is an appeal provision in Section 27 of the South Australian Act, which allows a person with a sufficient interest to appeal against findings. Now, that's a very different position from the one that we have, which is the form that was in the previous legislation, is in the current Coroner's Act, where we have Section 85. But we don't have an appeal mechanism, and this is a very specific option. So I'd call it a more confined statutory procedure. And I'd also describe it as the nuclear option, because basically what you're asking the court to do is to take the fairly extreme step of quashing the inquest or inquiry with all the uncertainty that that causes to the people who've already been through the process, and to go again. But you can succeed. Certainly there are cases where the application's been made and been successful. Probably many more where it hasn't been successful, but you can see why. In those sorts of cases, what you have to establish is the real possibility that the finding, the ultimate finding, was erroneous. But as you can see there, Section 85 is framed in broad terms, especially if you look at or any other reason. But in practice, the court will exercise restraint before agreeing to press the nuclear option. And as you can see there, it's not just quashing the inquiry. What goes with it is an order that there be a new inquiry. So, Tim's going to speak in detail, in fact, about reputation and questions of procedural fairness. All I wanted to do was to touch upon the idea that you've got Section 85, you've got broader rights of judicial review, but in practice, most of what occurs in the coroner's court will never be the subject of supervision in a court, in a different court. And so what that means is that for us as practitioners, it just makes it even more essential that we get it right first time at the hearing. So 3 things I guess I'd say come out of that, and they are: you should try to confer early with your witnesses, try early to identify documents and prepare witness statements well in advance of the hearing. Sometimes there will be last minute statements to be done, but generally it never ceases to amaze me how witnesses on the day of the hearing can say, here's a document that I brought with me that I haven't shown you before. Happens all the time. So obviously the earlier you start that process, the more that material comes out. And finally, I guess what I'd emphasise is that because it's so factual, detailed preparation is critical. And I would say that involving counsel at an early stage is a good idea if you're planning to involve counsel at a later stage. It's often good to have another perspective on it, especially from the person who's going to be on their feet. So with that, I will leave it there, and Tim's presentation I'm sure will have many more interesting things to it, including pictures of celebrities, so I'll just leave that. And I apologise for the lack of pictures of celebrities in my presentation, but I couldn't quite see how I could get them into my subject matter. But anyway, I'll leave that for now.
You're celebrity enough by yourself.
Thank you. Tim, over to you.
Thanks for that. It's got nothing to do with being a bass player, does it? I've how do this go? Yeah. So that's sort of where I start. Thanks, Hanan, for that erudite sort of, I think you described it as a cook's tour through the jurisdiction. I'm going to focus on, as Hanan said and Richard said in the opening, reputational risk and some tips on procedural fairness and how to manage, I think, particularly witnesses that are being called in the interests of clients you might have. There's probably more art than science to what I'm going to talk about. There are some grey areas, even the Bible, the Waller's is grey. So I'll be talking about some cases, but also be just giving you some observation from experience as well. And when it comes to the organisations that are being represented, one of the best things they can do is really look after their staff or whoever is being called on their behalf, who's going to have to ultimately perform really well under pressure. And as Hanan sort of highlighted in his conclusion, preparation and getting that right is really important. So, don't know what the relevance of this is, if relevance has got anything to do with the jurisdiction, but sometimes you can never live things down. And when it comes to adverse outcomes for, I suppose, really focusing on individuals who were called, the worst sort of grade is to have a referral. I think in the years I've been in practice, I've been in one case where, the police blocked everything off as a crime scene in a health case, and they were talking about manslaughter, and I've been in a recent death in custody where there was a fairly heavy-hitting prosecutor who was appearing for the family, and he'd had a referral for criminal investigation in a recent matter. What we're more often dealing with, and again, not so common is disciplinary referrals and other investigations. And again, in that case where I was against that prosecutor for the family was asking for a referral for investigation. It was a doctor in that case. So that's sort of the worst it can get. In the middle, there's sort of criticism and adverse comment. We can just sort of creep into the findings. Hopefully you'll be on notice, and that's what we're going to really sort of step through, tease out some of the issues about procedural fairness. One would expect that counsel assisting or the police advocate will give you some notice of criticism, or it'll be teased out in expert evidence. When you're looking at criticism and thinking about the end game and where your submissions are going to end up, you'd be wanting to have that scrutinised so that if there's going to be criticism, it's got to be based on a solid foundation of facts or evidence. And through this, I'll be discussing how some of that evidence can be tested. But obviously there's consequences. So as Hanan's highlighted in his presentation, no rules of evidence, there's limits on what can be done. And there are other forums for investigation of particularly professionals. You need to exercise a bit of judgment as to whether you want to highlight that, because it might be that the coroner or the family will think, oh great, if that's the forum, then let's refer it off there. But there is an inherent sort of lack of procedural fairness in having findings of fact relating to, as Hanan's discussed, responsibility in a forum where there's a lot of freebasing and less scrutiny to the process. So consequences are what we're concerned with. When Hanan's talked about manner and cause, he also talked about the issues list. There can be some dialogue with counsel assisting, those assisting the coroner in relation to the issues list, and occasionally you'll have success with perhaps having words such as reference to standards of care, compliance with standards, or appropriateness of conduct might get taken out depending on the personalities involved. When it comes to evidence, again on manner and cause, that's the primary focus. Recommendations been there for a fair while now. I think that's a latter development in the jurisdiction, but manner and cause is the primary focus. I try to make the submission about there being no hindsight analysis. Clearly hindsight's all over recommendations, and questions are put in terms of, looking back with hindsight. We're just trying to, this jurisdiction's all about learning from these tragic events. So with hindsight, what do you think you should have done? When it comes to manner and cause and judging someone's conduct, that should be done prospectively, and certainly something that I try to push, but with not always with great success. But the purpose of the evidence can be blurred, so sometimes there are questions that are clearly put with hindsight, and then other times not put in those terms. But then you might find that the witness's guard is down, and they're giving evidence about what in hindsight they should have done, and then it might be used to criticise them down the track. Hanan's talked about, I'll flick that because Hanan's talked about the practice note and cases about it's not a blame game. I've said go with the flow, I think, because for those of us who are litigators, it's really quite a different approach to have counsel assisting, those assisting the coroner, more in control of the process and calling the witnesses. The evidence has to go through those assisting the coroner, and usually gets in, subject to relevance. But I think one of the difficult things is letting go of the higher level of control you have as a litigant in other jurisdictions. And then it becomes a bit of a wild ride with, as Hanan said, the issues list can change from time to time. So what have you got in your armoury? Really, procedural fairness is the main thing. Relevance and other submissions can be made, but I'll touch on some of the things, again, trying not to overlap, but just recap on some of the relevant issues that Hanan's touched on. So in relation to Annetts and McCann, the coroner has the duty to act fairly when making decisions affecting interests. When it comes to the content and how that plays out in practical terms, a party, and that's a party who has a sufficient interest and has been put on notice by those assisting as having a sufficient interest, should have a right to be heard. So that means, as I've said down the bottom, even though there's no rules of evidence, procedural fairness really dictates that allegations that are made and are going to end up in a submission that someone's not acted appropriately or should be criticised, those propositions should be put. But going back to the content, it's really the right to be heard and an impartial decision maker. So, there are cases such as the Crown and Dugan out of the ACT bushfires where, the coroner was taken on about bias because of a dual role of a fire investigator who became an expert. We don't want to talk too much about Hanan and I have been in a bushfire thing where that very thing happened. I'll leave that because there's no findings yet. Practical aspects of procedural fairness. So as I've said, sufficient interest notice, that entitles you to leave to appear and representation and being able to test evidence by examining witnesses. I've been in a situation recently where I had instructions to represent the interests of 3 professionals, and one of them was not a party of sufficient interest, just told, oh, this is a factual witness. Of course, the evidence shifts, consequent on experts giving evidence, so the focus became on the person who did not have a sufficient interest. So things can change. It's a very dynamic jurisdiction. Hanan's touched on the findings of fact and how practical the process is, and also how important the fact-finding aspect is. And I think I've already touched on the manner and cause versus standards. So manner and cause, if you break it up, cause is really, what's the direct cause? If it's a death, what does the autopsy find as the direct cause of death? Manner really goes to those events or acts or conduct that contributed to the more direct cause, and that's where often, those parties that we're representing have their conduct scrutinised. So again, you might have some success with the issues list, and sometimes you've got this sort of circular process where the expert's defining the scope, and I'll talk a bit more about experts, but I've got there a point about the final brief. I've been in situations where, an expert opinion's given at an earlier stage because the coroner's trying to work out what the issues are. If it's a technical health case, for instance, there's complex medical evidence being given by, an expert, and that's based on a preliminary brief of evidence, and then you have the rush where all of the supplementary statements come in, and they're giving evidence on the run, and they may not have even read your client or your witness's statement. So I've been in the situation where I've said, can we just hold on, coroner? Your Honour, can the witnesses have 10 or 15 minutes to actually read the statement, and that's just stick to their guns on criticising whoever you're appearing for. But it is important that they be updated because the jurisdiction's so dynamic that all this evidence comes in late, and it may sway them, and they may change their opinion. I've had that experience as well. I'd agree with what Hanan said about objections, and technical objections are not often going to fly, but there is reason for making them when you want to set up a submission. On expert opinion, an objection I might make is to a layperson giving an expert opinion they're clearly not qualified to make. You might have less success with something like a nurse giving an opinion about a doctor's conduct. but that may be listened to depending on the coroner. And you can make submissions about appear in your final submissions, but it's good to set it up with an objection to say, Your Honour, object to this evidence. And that would be when the brief of evidence is really tendered. You could do that, or talk to counsel about doing that, so that you can set up a submission that, hang on, this person's in this field of specialty, and you've got someone who's from quite a different field of specialty who's criticising them. May not be listened to, but at least it'll make the coroner think carefully before that flows into the findings and criticism. I've talked, I think, about procedural fairness elsewhere. Hanan's talked about the rules of evidence. So despite there being no strict adherence to the rules of evidence, you can end up with a fairly similar sort of take on certainly putting propositions. I'll deal with that in the next slide, but it is fairly fast and loose, with there only being, there's a 1933 case from the High Court about delivering substantial justice, and the coroner really has the ability to inform his or herself about appropriate matters that have relevance to the fact-finding exercise. And the touchstones are really relevance and reliability, but there is a liberal approach, and that comes out of the ACT case of Crown and Dugan from the bushfires in the ACT. I'll move on. How are we going for time? Not too bad. So there's a case, Minister Philip Ruddock, ex parte applicant in the Refugee Review Tribunal. The High Court in that case said that there's no strict need to adhere to the rule in Brown and Dunn, and the Waller's textbook confirms that on page 164, that Ruddock applies in Coronials. It's an inquisitorial jurisdiction, but procedural fairness principles, a witness should be heard, as I said earlier, before adverse findings are made. And if a party, it might be the family in a death situation, intends to submit to the coroner that adverse findings should be made, or there should be a referral, then they should put that proposition in cross-examination before they go to that submission about the referral or the criticism. So that's sort of one of the tools in your armoury. So given it's an inquisitorial jurisdiction, and counsel assisting and those assisting the coroner are running the show, there are limits to what can be done, and I suppose you need to exercise your discretion about whether or not you should lead with your chin. And what do I mean by that? If there's a clear error that's been made, then that should probably be admitted. And there are admissions that can be made, certainly with hindsight, about missed opportunities. Obviously, and I think Hanan touched on coroners, assessing witnesses in different ways, and acceptance of weight of evidence and so on. But really, when it's key, as our role as representatives is to put those getting in the witness box that we're representing in the best position to present themselves well and have their evidence accepted. They need to sort of express some, candour and honesty and be straightforward to be accepted. So not be too defensive, and if it's a fair enough concession to make, then they should probably be admitting those things. And I'll talk about Section 61 certificates in a minute. But I've also been in the situation in an inquest about a young teenage fellow who is in a remote country, and the Westpac helicopter came to hopefully rescue him. It didn't quite work, unfortunately, but there was a lot of evidence about the ambulance service coming to pick him up, and then with storms, the Westpac helicopter makes it through the storms, and then they had to work out where to go, and unfortunately he died en route to a hospital he went to a couple of different hospitals, but when I was appearing for the retrieval doctor in the helicopter, just before he gives evidence, there appears a photo of the fatal wound, which was clearly relevant to the coroner's investigation, and there is a decision that needs to be made with instructions about some key evidence that really the coroner needs, and you've got to make that call about your client's interests and where to go with that. But obviously, if you're not candid with the coroner, you're trying to hide some evidence, or you're trying to not be straight, you're not going to come off well, and you're more likely to get criticised. Another factor, the sort of softer factor in there with sort of avoiding a referral or criticism, is demonstrating insight and lessons learnt, which factor into how an organisation responds, but also individuals. I mean, the disciplinary jurisdictions are often about safety and being up to date, and learning lessons as your career develops. So a coroner will form a view about safety and being up to date. So insight and being open to lessons learnt is an important factor for those witnesses to avoid a referral or criticism. So I think Hanan and I have both stated the obvious, that witness preparation is key. It's probably, if there's one thing that you can do well, that would be it. I do a bit of work in the disciplinary jurisdictions and in inquests where anyone who's criticised, there is a bit of a grieving process that witnesses go through, and a series of conferences, if you can afford it, depending on who you're appearing for. I'd say 2 conferences would be ideal, even if that's an early morning, the day of giving evidence, preferably an afternoon or 2 before they actually hit the witness box. Sometimes that's not practical. I've had people arriving in planes during inquests and having to give evidence a couple of days later. But that just to allow that grieving process that witnesses go through when they're criticised, and how you can then put them in a good position to present themselves well, and not you get any surprises in the witness box. And another aspect of that is, I suppose particularly these days with audio visual links, any witness who's giving evidence should have access to the relevant material that's going to be put in front of them, be it an expert that you're going to cross-examine. How do you cross-examine an expert if they don't have the brief of evidence in a complete form and you can't show them documents? So, I mean, often at LIDCOM there's a facility for documents to be put on the screen, but you're not always in that forum. I think it would be good for relevant witnesses to have some familiarity with the relevant material before they hit the witness box and know that everything works. If you've got someone giving evidence in person, then it's good to let them get the vibe of the room and the questioners, counsel assisting, or if there is a pugnacious person appearing for the family or whoever. That doesn't always work. I've had one recently where I had the 2 conferences, and the doctor I was appearing for came and didn't get on in the afternoon and listened to the afternoon's evidence. I said, "See, I told you he was going to rush you. He's going to have an elevated tone and he was going to try to push you around." He gave evidence the next day and completely lost it, and was asking the coroner if he could speak to me in the middle of cross-examination. So sometimes it doesn't work, but all we can do is put every effort that we can and use every tool that we can to put those that we represent in a good position. Another one that I would cautiously let those who are potentially being thrown under the bus about is Section 61 certificate, which I've sort of veered away from for a fair while and had recent experience with. So Section 61, there's a privilege with respect to self-incrimination, and the coroner will often listen to it if there is a fair bit of scrutiny of the witness's evidence. And the provision in sub 1 is if the witness objects to giving evidence, usually they've been advised about evidence that may tend to prove that they've committed an offence or have be liable to a civil penalty, and that can include disciplinary proceedings or investigation. So they'll be given a certificate under sub 5, and under sub 7 the evidence obtained can't be used elsewhere, but there are limits to that protection. It only protects the witness with regard to their own evidence. It doesn't protect them with regard to criticism by experts. It doesn't protect them with regard to other witnesses throwing them under the bus. So there are limits, but some witnesses draw comfort from it, and particularly if you're sort of on notice that someone might be seeking a referral for investigation elsewhere, then it can be handy. But balanced against that is if there's not a real need for it, you're going to highlight, and there's no utility because there's other evidence, and you might be highlighting an issue unnecessarily, so matter for consideration. I think I'll probably time to finish up. So serenity is a good thing. There's some things that you won't be able to change. There's different types of serenity, but I'll talk about institutions briefly. So as Hanan's touched on, marshalling evidence, particularly for an institution, system improvements are key. If there's evidence that whatever recommendations would be proposed by those assisting the coroner or the family are already in train, there's already work done on protocols or training to improve those systems, then you may well avoid a recommendation, and that's something that a lot of effort's put into. Sometimes there can be a trap for young players in that there can be a beautiful shiny protocol that's rolled out and attached to a statement, and then the next witness is cross-examined about have they had that training or were they aware of that policy, and they weren't, and there's not a great look there. So it's not just having a policy or a protocol, it's also the implementation of that. And there's often, if there's enough time to get the evidence together, percentages of people trained and staging of rollout that will reassure the coroner and those assisting, and may not result in a recommendation. And as Hanan again mentioned, that rapport with counsel assisting will allow you time to hopefully have some notice of the proposed recommendations, and if you can, try to find out what the family's thinking. If they've got representation, they'll have their own say about recommendations. I think I've done a couple of inquests for families, but I think they can often be the elephant in the room as far as they'll be shadowing counsel assisting, and then they'll come at you fairly hard if there's need for that. So anticipation and time to obtain instructions is usually listened to by the coroner, because sometimes there's a bit of detail in the submissions required in relation to proposed recommendations. Hopefully some of the tips we've given you will assist you so you don't end up like Frank Costanza for the Seinfeld fans, and you're not requiring that sort of serenity. But happy to take any questions, and Hanan and Richard's obviously got a lot of experience to answer any questions as well. We've got the possibility of some online questions.
Yes. Yeah.
Happy to take any questions on point on the presentation or otherwise.
I have a question. So Hanan, you were talking about when your witness potentially brings you a piece of evidence in the morning of, say, the hearing. Procedurally, how would you go about presenting that evidence or tendering that evidence? And, so would it be more receptive to contact counsel assisting or pull them aside, or would you just tender it when the court's open, for example?
Well, it has to be done through counsel assisting. So,
Okay.
So typically what you want to do is work out, I think as Tim was saying, at an early point, are you going to deploy this, or are you going to seek to deploy this? And once you've made that call, you're going to have a conversation fairly quickly with counsel assisting to say, here's this evidence, we think it's going to assist the coroner, this is important material, it's relevant, and it should be included. Now, as Tim was saying, it's very often the case that there are lots and lots and lots of late statements, so you won't be alone, and even in the course of an inquiry. I won't say anything about a particular inquiry that Tim and I are both in at the moment, but just to say that very often evidence that emerges in the middle of the inquiry can substantially change everything. And we're in a case right now where that in fact happened. There's nothing wrong with it, because even doing your best, sometimes it happens that way. I mean, I've had a commission of inquiry that I did when I first started at the bar, where I was talking to my client over the course of months, and on the morning of the hearing, my leader, who was based in Queensland, the witness comes along and says, "Oh, here's some documents," and it made it look as if I hadn't been talking to this guy at all, whereas in fact I had been talking to him over a long period of time. People are human, it's the best we can do. But I do think you want to be having that conversation with counsel assisting as soon as you can, once you form that view.
Just add something in terms of practice.
If you have something that you really want to get before the court and the coroner, and you're getting a bit of resistance from counsel assisting, of course there are other ways to bring it to the attention of the court. You say, well, look, I'm going to make an application, or I want to say something, in which case you can say something to the coroner once the court's reconvened, at which point the coroner's going to know then you've got something, and you, at least from the point of view of the interests of your client, you think that fairness dictates that that document or thing or whatever it is should go into evidence, at which point counsel assisting will then have to say to the coroner, well, this is my view because X, Y and Z. So there are other ways of doing it.
Okay, thank you.
Are there any remote internet questions? Everyone's entirely satisfied. That's fantastic. I'm reminded at this point by a comment by a now Supreme Court judge, former president of the Bar Association, who said that attendance at CPDs is compulsory, but questions are not. So you've obviously all taken that on board. No questions? Everyone's happy? Excellent. There's some wine to be finished, or mineral water, whatever you choose. You're all dismissed, I think. Thank you very much for attending.